Good day to you and welcome to another Paddocks Club video tutorial. Today I'd like to talk to you about Geyser guarantee records. This subject arises from a question asked by Karin of Trafalgar on the discussion forum. She asked, who would you say would be responsible for the call-out fee for the plumber if they are called to a unit only to find that the geyser is still under guarantee? Well, I asked her for a bit more information and she explained that the residents had contacted Trafalgar's after-hours emergency number, and the lady at the offices in charge of the phone sent out a plumber. When the plumber got there and inspected the geyser, he saw that it was still under guarantee, so he couldn't do the work. And she explains that the lady that deals with the after-hours emergency number has no idea or records as to which geysers have been replaced and which are under guarantee and which are not. Now, it's an interesting situation which I think will apply to a number of schemes. And I suppose the ideal arrangement is to have plumbers who are prepared to go out on risk on the basis that if they find they can't do the work because the hot water cylinder is under a current guarantee and somebody else must nominate the plumber, then they won't charge. That's ideal, but obviously not always achievable. If you think about it, there's a call-out fee, it's got to be paid by somebody. And so one says, well, who will pay it in these circumstances? Now, the logic, I think, is that if the plumber had been able to do the work, it would have been covered by the body corporate's insurance, perhaps less an excess amount that the owner would have had to pay. But when it turns out that this is an unavoidable wasted cost, then the question is the owner liable, is the body corporate liable, or is the managing agent liable? Well, the managing agent will only be responsible if its employee was in some way responsible for the wasted expense. So, for example, if the trustees had said, no, you must keep a list of the guarantee situation so that you know when a call comes in who should be contacted. And that certainly wasn't the case in this particular instance that Karin raised. But I think in other circumstances, it should be the owner rather than the body corporate who's liable for that wasted cost. Because if you think of it, the prescribed management rules make the owner primarily responsible to repair and maintain the hot water installation. And it is just a reality that the body corporate's insurance actually covers that thing. The primary legal responsibility is with the owner. So if there is an otherwise unallocated cost, then the owner should pick it up rather than it being paid by all the other members. But I think there's a lesson to be learned here. If your scheme has an arrangement that owners can call a plumber or the managing agent who will arrange for a plumber, then you should either make an arrangement that the plumber who comes out works on risk until he knows that he can actually do the work, or alternatively, somebody should be keeping a list of the geysers and whether or not they at any given time are under guarantee. Then you know who to contact when they fail. If you have any questions in this regard, please raise them in the discussion forum.